Okay, great. The Court of Appeals for the 8th District of Texas is now in session.
Thank you, Ms. Flores. And the court calls County of El Paso versus Crystal Mijares and Melissa Alvarado from El Paso, and Mr. Gomez representing the County of El Paso, and Mr. Baeza representing Ms. Mijares and Ms. Alvarado. Is that correct?
That's correct, Your Honor.
Okay, and I just, we are allowing 25 minutes for the appellant and the appellee and 10 minutes for rebuttal. And we have had an opportunity to review the briefs and the record and have a discussion so we understand the underlying facts, if that aids you in your presentation. And we also have, if you can see, we have the timer on. So I think Mr. Gomez, you're first, and I'll keep an eye on the timer in case you start going over that time. I'll let you know. All right.
Thank you, Judge.
Okay, you may begin.
Thank you. May it please the court, counsel for the appellees. Good morning, Michael Gomez for the County of El Paso. First and foremost, the county would like to clarify that it is not asserting immunity from all breach of settlement agreement claims. It's asserting immunity specifically to the appellee's claim because the agreement did not impose a non-conditional contractual obligation to rehire the appellees. Instead, the agreement calls for a promise of a substantial payment close to $50,000 and the possibility of rehire should the appellees be approved for employment.
Mr. Gomez, do you mind repeating your statement? Slow it down a little bit.
Yes, I apologize, Justice Palafox. Yes, I am saying that the county is not asserting immunity to all breach of settlement agreement claims. It's asserting immunity specifically to the appellee's claim because the settlement agreement in this case did not impose a non-conditional contractual obligation to rehire the appellees. The agreement in this case instead calls for a promise of payment of substantial amount close to $50,000 and the possibility of rehire should the appellees be approved for employment.
Mr. Gomez,
Yes.
Isn't that entirely a question of the merits of the interpretation of this settlement agreement in order to invoke this court's interlocutory jurisdiction over the denial of a plea to the jurisdiction? Doesn't your argument have to be an argument about this court's, or I'm sorry, the trial court's jurisdiction to entertain the merits of that dispute in the first place?
Right, we are saying that this missing, the missing condition precedent, the underlying condition precedent is the missing jurisdictional fact because without it, the appellees do not have a valid cause of action that would pierce the county's immunity. We are, the county concedes that the county's waiver immunity, that the county's immunity could be waived should the appellees be able to bring forward sufficient jurisdictional facts to show that they have a valid cause of action that would pierce the county's immunity.
You know, my question, Mr. Gomez, is how does the Texas Supreme Court's case in Lawson, which allows for breach of contract claims on settlement agreements, if the underlying lawsuit that was settled, the county's immunity is waived, how does that impact your immunity argument here?
And maybe I'm not, I want to be clear that we're not saying that the county is immune to all breach of settlement agreement claims. That's not the county's position. We're saying specifically in this case, the appellees are required to show that they or to prove that they have satisfied the underlying condition precedent because the county has negated the condition precedent. And so the burden shifts back to them to show that they have proved the condition precedent, to show that they, to show that the county does indeed have a contractual obligation to rehire the appellees.
But Mr. Gomez, again, the plaintiffs in this case have alleged that all conditions precedent have been satisfied. So to the extent that could even be considered a necessary jurisdictional fact, it's been alleged. And so do you have any authority that would support your argument that this argument that you're making, a legal argument about the interpretation of the contract that's in dispute, can be appropriately considered at this jurisdictional stage?
So the argument that I'm making, it's a little bit, it's twofold. First, I concede that the appellees did say that they satisfied all their conditions precedent, and I concede that Rule 54 allows for a general aversion to allege as much. However, also Rule 54 in case law say that when the party negates specifically the satisfaction of a condition precedent, then it goes back to the plaintiff to show that they have satisfied the negated satisfaction of the condition precedent. A case that comes to mind is Gray, that's 228 Southwest 3rd at 431. And that is citing Texas Supreme Court case Beatty LaVille, and that is at 669 Southwest 2nd, 102, 104. Both of those cases say that when a party specifically denies the existence of a condition precedent, then it goes back to the party, to the plaintiff to show that they have satisfied the underlying condition precedent. Then you put that together with all the jurisdictional cases, or all the cases talking about the sufficiency of jurisdictional facts. We go to Alamo, to Miranda. And in all those cases, they say that when a party, when the defendant challenges the existence of those jurisdictional facts, then it goes back to the plaintiff to show that they have sufficient jurisdictional facts to overcome the appellees, to overcome the county's immunity.
So Mr. Gomez, does the county concede that the immunity had been waived for the underlying suit?
With regard to the plaintiff's, to the appellee's fraud and fraudulent inducement, no, the county asserts full immunity because it is immune pursuant to the Texas Tort Claims Act. With regard to the breach of settlement agreement claim, we agree that we would waive immunity if there was a valid contractual obligation.
Well, I mean, originally, with the original claim that the plaintiffs brought, which led towards the settlement agreement, does the county concede that there was a waiver of immunity for those claims, whatever the county actually settled?
For the first underlying case, with the FMLA, yes, I think that, yes, I agree that the county concedes that would have, if that case would have gone forward, it would have been a waiver of immunity. Yes.
So are you then saying that when the parties completed this, the formality of entering into the settlement agreement, that immunity returned to the county, and then now you need a condition precedent, or condition precedent before the breach of contract claim itself can proceed?
Not exactly like that. Just what we're saying is, if I am allowed to change the facts a little bit, let's say that the county never paid the substantial amount, close to $50,000, that was promised in the agreement, then that in itself would be something that would be a breach. That would be something that the appellees can claim, yes, this is a breach of agreement because that was a promise within the agreement. The county is saying that the agreement itself does not call for the unconditional promise to rehire the appellees. We're saying that the county is under no contractual obligation to rehire the appellees, and because they're not under the contractual obligation, the appellees have not put forth a valid cause of action. If there was a contractual obligation to rehire the appellees, then yes, there would be a waiver of immunity.
But why isn't this just an argument about the merits? I mean, you can make all the same arguments on your summary judgment motion as I think you have, but what makes it jurisdictional? I mean, what would be wrong with us concluding that, if there's a dispute about whether there's been a breach of this settlement agreement, the court has the jurisdiction to decide that. And these arguments that you're raising simply go to the merits?
Well, Justice, since the county is a unit of local government, the appellees are required to plead a cause of action that pierces the county's immunity. If they don't have a cause of action that pierces the county's immunity, then the court doesn't have jurisdiction. That is
Right, but how have they failed to plead the cause of action? Your argument goes to the merits. You're saying on the merits they lose, but this appeal has to be about a jurisdictional question. Does the court lack the authority to even decide? And it seems like you've essentially conceded that it's possible for there to be a scenario where the county breached this settlement agreement and a court could be called upon to decide it. And your argument seemed to simply go to the merits, that you have a disagreement about whether there was a breach or not. But why does the court lack power to decide that dispute that's been pleaded by these plaintiffs?
the argument that I'm making, it's intertwined with the facts. I concede to that, Justice. It's intertwined with the facts, but those jurisdictional facts are the ones that must be pled before the appellees have a valid cause of action. The law recognizes, for example, in Alamo, there's going to be cases where there are intertwined issues of fact and law, and within those cases, that still creates a jurisdictional issue or question of law for the court to decide whether or not the parties bringing forth the cause of action have pled sufficient facts to show that the court has jurisdiction.
Well, that's why I'm curious about whether you've got any authority that relates to this scenario, because it doesn't seem to me that you've identified any failure of jurisdictional facts. What you've got are legal arguments about how to interpret those facts, and that seems to be purely a dispute about the merits.
And the argument that I'm making, Justice, I am making it more than anything using the Alamo reasoning where it says that when the waiver of immunity is conditioned on the existence of a valid cause of action, then the elements of those cause of action become jurisdictional facts. Here, the waiver of immunity is conditioned on the existence of a valid cause of action. Specifically, it's conditioned on the existence on a breach of a contract, breach of a settlement agreement claim. There cannot be a breach without satisfaction of the underlying condition precedent. And so using the reasoning in Alamo, we are saying because the appellee's claim is conditioned on the existence of a valid breach of settlement agreement, then this lack of condition precedent or satisfaction of condition precedent is a missing jurisdictional fact, because without it, you don't have a valid cause of action.
Well, correct. Go ahead.
I'm hearing Alamo. Are you citing Alamo Heights v. Clark? I'm just making sure.
Yes, Justice, I apologize. Yes.
Okay.
And so if memory serves me correctly, I mean, when we're looking at a plea to the jurisdiction, we are required to look at the petition and assume for those facts to be true. And so you're saying that once you challenge one of those facts, then the burden shifts over to the plaintiff to put forth more evidence. It's more like a sufficiency. To me, it's not really facts. It's more you're alleging like a legal insufficiency argument about the jurisdictional facts, which kind of backdoors, which is Judge, I think, Massingale's point, backdoors the merits claim.
Well, I can see, Justice, that we are arguing. I agree that we are arguing the facts in the case, and so it's exactly right. Once we challenge the existence of the jurisdictional facts, then the burden goes back on the appellee to show, enough proof or to counter, in this case, the county's position.
Well, and I guess the other thing I think we probably need to be clear of, to me, it's not so much jurisdictional facts as it is interpretation of the settlement agreement. And your view of the settlement agreement is that there is no breach of the settlement agreement because legally you take a particular position of the interpretation of that settlement agreement, that is contract, whilst the plaintiffs and the appellees take another legal interpretation of the contract. And and so it's not so much jurisdictional facts as it is interpretation of the contract is what you're asking us to perform. Is that not correct?
The interpretation of the contract would arrive to the same scenario, yes.
And just so also then to be clear, if the allegation had been that the county had failed to pay the settlement amount, you're conceding that in that allegation, there would be jurisdiction alleged?
Yes.
So you're saying that for us to do the jurisdictional analysis, we need to, in this case, in this scenario, you'd be looking at these contractual terms separately.
Well, I think the contract terms are separate. The question that the only thing that the appellees are complaining is this lack of rehiring. They allege that they have not been rehired. The county's position is there was never a contractual obligation on the county to rehire. And so you're absolutely, well, this is where Justice Rodriguez's argument, if the contract's interpreted as requiring a condition precedent, it gets us to the same conclusion. But because the appellees are saying that they are not required, and we try different ways to get them to say how it is, or how is it that they interpret the settlement agreement to see how it is we can defend this case, then we get back there because let me retract a little bit. Our whole position is that the appellees were never promised employment. They were promised a substantial amount of payment, and that was paid. The appellees are now claiming through their breach of settlement agreement that they were not rehired. What we are trying to get the appellees to do is to tell us why it is that they feel they need to be rehired. We have negated specifically the satisfaction of the condition precedent, and yet, despite the fact that they've had ample opportunities to amend their petition, they continue to just allege that it's been satisfied, a general version that's been satisfied.
Let me ask you, Mr. Gomez, let's assume for the moment that the way I understand the terms that you're asking us to interpret for you as part of your plea to the jurisdiction is that if the way I understand it is your position is that the settlement agreement essentially promised to consider them for employment if a particular department head or somebody offered them a position, but basically it's we will consider hiring you over this time period if you apply. Basically you were saying there's no bar. You were not putting you on the list of ever barring you from working at the county any longer, right? So that's your position. So what evidence have you put in the record that shows that these individuals were in fact considered for employment?
Well, the appellees have interviewed for several positions.
And that's in the record?
It's in the record in the depositions.
Okay.
Yes, sir.
And they were and the department heads considered their employment.
Yes, I believe at the very least on one of the occasions with Ms. Mijares, she had an interview with HR, and then she failed to show up for her last interview.
Okay, so but part of it is that if somebody offers her job or considers her for a position. So you're saying that the depositions of the plaintiffs said that they were interviewed for a position, but there's no jurisdictional facts to indicate that anybody considered them.
Well, I guess the county's position is that because they were interviewed, essentially they were considered for the position. They don't interview just anyone, they interview the top candidates. And because they were one of the top candidates, they were considered for the position.
And that's in the record.
Yes.
What you're just telling me, where in the record does a county official say, because they were interviewed, they were considered for the position?
Not as specifically on that, exactly like that, Justice.
Yeah. So that's the thing, I think, is the difficulty, I think, that we're going to have, even if we were to assume your interpretation is whether or not the evidence in the record is going to allow us, if we take your view, whether or not the record, if there's enough evidence in the record to allow us to see that that's in fact been done. I mean, I mean, that's part of the problem. I will tell you, in all of these jurisdictional cases, is that the record and the evidence generally, you're at the beginning, you're at the threshold of the litigation, and the evidence is usually, there's, a summary judgment motion usually allows you to develop the evidence, in a way that can be challenged, because that would be something that I would be looking for in the record is where is the evidence that the county, in fact, genuinely, authentically considered this individual, and where can I rely on that?
I think that, and the evidence in this case would be the lack of evidence showing otherwise in this case. Discovery has been ongoing, or was initiated, the lawsuit initiated almost 7 years ago. The parties announced ready for trial, and in fact, we were about to go to trial last October. And so there's really no other evidence that would have come about to show otherwise. The evidence before the court would have been that they interviewed for positions. There's nothing indicating in the record that they were not taken seriously. And again, the promise in this case was for payment and not employment. And so absent any contractual obligation on the part of the county, the only thing that the county was really required to do was to have the appellee, or to pay the appellees the settlement amount and allow them to remain eligible for hire. Here, the county satisfied its duty, or kept its end of the bargain and paid the amount. And still to this day, despite the fact that they're not interested in employment, despite the fact that they're employed elsewhere, or despite the fact that they haven't even applied for the county in the last 6-7 years, they still remain eligible for rehire.
So
And that's the record.
That is in the record, Judge.
So Mr. Gomez, then from a jurisdictional point of view, does the county consider these two individuals, the plaintiffs, are they no different than any other person that is applying for a job position for the county? Meaning there's really no contractual obligation at play, there's no waiver of immunity at play. Is that your point of view, that they basically come to this litigation no different than any other person who may have applied for a position and not been offered employment?
And yes and no. They have the same. They start out the same like any other applicant would, where they would have to apply for a county position. However, in this case, there was obviously a working relationship with the county before, and so they knew, for example, the head of HR, and they also knew one of the employees at HR, and they were told to try to help you out, to try and help you in a good gesture. Why don't you tell us each time you apply, and we'll try to get you interviews. With one of the applicants, that was happening with Ms. Alvarado. She did notify HR, so she would get interviews more frequently than Ms. Mijares. With Ms. Mijares, she was not notifying HR. I believe she only notified HR during her last application, which happened sometime in December of 2013.
Well, but my question is really trying to focus on the immunity status of the county with regard to
Yes.
these two applicants.
Yes, in that respect, yes, they would be treated the same, Justice.
Okay.
And I think what I would like to clarify is, or just to answer that last question, Justice Palafox, the only difference or the only reason why we would include this eligibility for rehire is because this eligibility for rehire in itself, there's some value to it. For example, if I were to leave the county and I were to come back, if I'm eligible for rehire, I can pick up where I left off on the retirement. I can pick up where I left off, for example, on my school loan forgiveness. And so it's always best to be eligible for rehire. So that's the reason that was included in the language.
Okay.
And I see my time's almost up. So with the court's permission, unless the court has any questions, I'll reserve the 18 seconds. Thank you.
Mr. Baeza.
May it please the court, counsel. My name is Jonathan Baeza, and I represent the appellees, Ms. Crystal Mijares and Ms. Melissa Alvarado in this matter. Now, because the county agreed to settle classes of claims from which it was not immune, an FLSA overtime claim and an FMLA medical leave claim, it cannot now claim immunity from this breach of settlement agreement suit. Now, the lower court denied the county's plea to the jurisdiction, and the appellees pray that this court affirm the denial. Now, the court has requested that I focus my argument on the basis for which immunity has been waived. But prior to doing that, just a quick recitation of the facts regarding applications as it was discussed in the questioning. The appellees did fulfill their obligations in regards to applying or approving positions. In fact, they applied for a combined 21 positions over 1.5 years between June 2013 to May of 2015. The appellees were qualified for each position, and each position was vacant. At no time did they receive a job offer. Now, focusing on the basis for which the appellees believe immunity has been waived by the county, I'm going to cover 4 main points. First, waiver of immunity based on the Texas Supreme Court case Lawson and the 8th Court of Appeals case in Hamilton. And these are the court's holdings on waiver of immunity in settlement agreements. Second, I'm going to discuss that a fact issue exists as to whether the appellees performed. That's element 2 of a breach of contract claim. In that portion, I'll discuss the condition precedent, covenant, and some ambiguity. Third, we will discuss whether a fact issue exists as to whether the county breached its duty to perform, which is element 3 of a breach of contract claim. In that portion, I'll discuss the county's actions that were inconsistent or which interfered with the performance of the contract, resulting in a breach, and the county's duty to obtain consent of the deciding officials, and the county's duty to rehire the appellees. And finally, I'll discuss the fraud and fraud inducement claims and the appellee's basis for waiver of immunity and how that interplays with the Lawson and Hamilton waivers. Now, the issues presented before by the appellant's plea to the jurisdiction was not a legal question reviewed de novo, but it's really a question of whether evidence existed to support the merits of appellee's suit. That's what they're asking. They want this court to decide whether the appellees have proved their breach of contract claim. They're not asking to decide jurisdictional issues. They're going far beyond jurisdictional issues and saying they have to prove their entire case at this point to go forward. That's a motion for summary judgment. And it's important to note that there was a motion for summary judgment filed in the lower court. There was a motion for summary judgment response filed in the lower court. But in the end, that was not heard outright. And instead, the county filed its second plea or first amended plea to the jurisdiction. And that's why we're here today. Well, in a plea to the jurisdiction, we look at jurisdictional facts. And And if the evidence creates a fact question regarding the jurisdictional issue, then the trial court cannot grant the plea to the jurisdiction. And Justice, you were right. This court should credit as true all evidence favoring the non-movement, that's the appellees here, and draw all reasonable inferences and resolve any doubts in non-movement's favor. The court must determine what conduct is required of the parties under the contract. And insofar as a dispute exists concerning a party's failure to perform the contract, that's for the jury. In other words, if there's a fact question and if it goes to the merits, that's for the jury, that's for the fact finder. Here, a dispute clearly exists. A dispute exists as to whether someone performed or someone breached. Therefore, the plea should be denied. Just to touch quickly on the cases discussed by the appellant's counsel, Alamo and Miranda. He relied heavily on Alamo saying, and it's the county's position, it seems, that Alamo states that appellees or plaintiffs have to prove their entire case, the merits of their claim, before they can move forward in the courts. And that's not the case. In fact, Alamo, all of the cases that lead up to Alamo say that, and this is in appellee's brief, a plea to the jurisdiction should not wade too deeply into the merits. And at times they may intertwine, but a valid plea does not wade too deeply into the merits of a claim. And here, that's exactly what the county's asking you to do, to, in other words, decide the claim outright.
Well, it wouldn't require us to reach the ultimate merits if, in fact, what we had to determine is whether you have actually pleaded a claim that creates a fact issue that ultimately would have to be determined in the court. Do you understand the difference?
I do, Your Honor.
Okay. And so do you have any authority that supports your position that what you've done here is enough to clear the jurisdictional hurdle and you should not be required at this stage to demonstrate as a matter of law that the county's interpretation of the contract is wrong, and in fact, you've got a live fact issue that can go forward?
In regards to whether there is a specific site, we would have to look at the entirety of the case law that leads up to Alamo. And essentially what Alamo says, if there's a fact issue regarding any of the elements, that's for the jury. So in this case, if the court finds
but wouldn't this sort of be similar to the issue that is in the summary judgment motion that was filed in the trial court? I mean, if the trial court were to decide the summary judgment question in the county's favor, that would imply a determination that there is no fact issue. The county's interpretation of the contract is correct. There is no fact issue, and so then the case is resolved as a matter of law.
And this is the county in their motion for summary judgment made the same argument. So they double dip. They filed a motion for summary judgment and a plea to the jurisdiction. But in regards to the jurisdictional issues here, the Hamilton court and the Lawson court very clearly stated, in regards to settlement agreements, a governmental entity can't claim governmental immunity once it enters into a settlement agreement in which the underlying claims of that settlement agreement, they've waived sovereign immunity. They can't come back and do that. And
right, but the county is not arguing that you can't sue it on a breach of a settlement agreement per se. The county is saying you can't sue it on this theory under this settlement agreement because they're saying as a matter of law, you haven't presented a dispute where there's any fact question.
And so it's the responsibility at this juncture, it's the responsibility of the appellees to show that there is a fact question. I'll agree to that point. And I believe that the appellees in their petition have shown that there is a fact question regarding either the interpretation of the contract, whether that specific clause is ambiguous or not, As we see here today, there's two susceptible interpretations to that specific clause, and the court can find, it's up to the court to find whether that is an ambiguous clause or not. And if it is ambiguous, that's a fact issue for the jury. Two, in regards to the elements of the claim, duty, breach, right? If there's a fact issue as to any of the elements of the claim, if there's a fact issue shown here, then that fact issue should go forward to the jury. And
So do you think that we should decide the disputed question about the interpretation of the contract to resolve this appeal?
I don't believe that's necessary. I believe if there's a fact question on any of the elements of the claim, then that's for the trial court and then the jury. This question, the legal question, that's a merits issue. That's a legal issue for the trial court. This court, what the county is asking this court to do is to sort of backdoor the trial court's responsibility, and instead they didn't get the decision they wanted from the trial court. So they're asking you to decide what's on the merits, whether this matter, whether the plaintiff has pled facts that state the county did in fact breach the agreement, or whether the plaintiff did in fact plead facts showing that the plaintiff performed and therefore the county is required to perform at this point. I don't believe that entire fact question, that the merits of the claim should be decided by the Eighth Court of Appeals in this issue. I believe that is for a motion for summary judgment that is specific to the merits of a claim. In regards to Alamo and Miranda, those claims, those jurisdictional questions are TECRA claims. Those are employment disputes. And the reason they go to the merits of the claim is because in employment disputes, you have the prima facie claim, the prima facie case, which you have to first pass, and then the burden shifts to the defendant. Then if there's a legitimate business reason, then the burden shifts back to show pretext. And that case is very different from this case. That case, and TECRA specifically, states in order to bring a cause of action against the governmental immunity, you have to have a prima facie claim.
I'm sorry, which case were you just referencing?
Alamo Heights. That is
Alamo
the
Heights.
second one.
Alamo Heights and Miranda. And so what you're saying is that those cases are about the McDonnell-Douglas shifting framework.
Those involve McDonnell-Douglas factors, right? They involve prima facie claims.
Prima facie claims and this, okay, I see what you're saying.
This is not a prima facie claim. This is, are there jurisdictional facts on the pleadings or in the evidence that creates a fact question? Did the county breach? Did the county not breach? Did the plaintiff perform? Did the plaintiff not perform? And the trial court can decide that on motion for summary judgment when it receives all the evidence and decides whether it goes to the jury. Or the trial court can decide, is this an ambiguous contract? And if it is an ambiguous contract, that should go to the jury. That has not been decided at this juncture. That is for the motion for summary judgment. Those aren't jurisdictional facts. Those are merit facts. Those are facts that go directly to the merits of the claim. That being said, I believe that the appellees have shown that a fact issue exists. Fact issue exists as to, is this ambiguous or not? One, as we saw here today, there are two susceptible interpretations to this very specific will be rehired statement in the contract. Now, the county has attempted to rewrite the contract and say that it's eligible for rehire. And we can see today that the county understands how to use that term, eligible for rehire, but nowhere in the contract does it state that. And then the county goes on to cite the Gonzalez case, but that case is distinguishable. That case, the plaintiff agreed it was an eligible for rehire clause. The plaintiff never said, this is a straight out reinstatement issue. The plaintiff agreed with the interpretation and said that the defendant failed to do so. Very different issues here. Here, the appellees do not agree with the contention that it's merely an eligible for rehire claim, but they say, no, this is a reinstatement issue. In fact, in the record, Elsie West, who is the HR individual handling these applications, said she handled, or she was supposed to handle these Ms. Mijares and Ms. Alvarado's applications just like a reinstatement issue. Use the reinstatement policy is what she said. That is in the clerk's record 313, my apologies. Clerk's record 313, page deposition of Elsie West, 43, lines 1 through 3. She said, reinstatement, follow the reinstatement policy. And in clerk's record 554 through 557, we see the reinstatement policy. And it very clearly says that a reduction in and reinstatement specifically for a reduction in force individual. That's what she says. And a reduction in force employee is reassigned to available positions for which they qualify through coordination by HR, and they receive preference for the vacancy. There's a fact issue as to whether the county acted inconsistently with their duties. Did the appellees receive preference? And the record is clear, no. How do we know that no, they did not receive preference pursuant to this policy? Because Elsie West testified that she would not recommend an interview for Ms. Mijares or Ms. Alvarado if they did not score the highest scores on the test. That is nowhere in the contract where it requires them to score the highest. It says approve and apply. That was an additional requirement required by the county. That's not preference. 2, the county did not recommend the approval by the department head or official. In fact, Elsie West testified in clerk's record 312 that there were some department heads that asked her, are you recommending that I hire these individuals? And she would say, no, I'm only recommending an interview. That is not preference. A reasonable majority.
Mr. Baez, I'm worried about your time. So if you don't mind, can you at least touch on the fraud and the fraudulent inducement claims with regard to the jurisdictional question?
I can, and this is a novel issue, I'll grant you. In regards to fraud and fraud inducement, the county has immunity. The county has immunity for breach of contract claims if they don't fall under 271.152. That is true too. What the courts in Lawson and Hamilton have said is, again, once you have a settlement agreement and the underlying claims, you've waived that immunity, you can't go and claim some sort of governmental immunity on a following claim regarding that breach of contract. And here, the fraud and fraud inducement are specifically related to the breach of contract claim. It is the appellee's contention that they were fraudulently induced by statements made by the county to reach this settlement agreement. As Mr. Gomez said, this rehire portion had value. They took, and the appellees in their deposition stated, they took less money because a job with the county was more important.
But Mr. Baez, so what you're suggesting would be a significant expansion of what the Supreme Court said in Lawson. It's one thing to say that when a governmental entity enters into a settlement agreement with respect to some dispute for which there's no underlying immunity, it doesn't somehow cloak itself in immunity for a future claim of breach of the agreement. You're seeking to add to that a new exposure to liability for a fraud claim or a fraudulent inducement claim. And not only do we have the Texas Tort Claims Act where the legislature has specifically outlined what categories of tort liability are, the immunities being waived for, but it also seems to me that what you're arguing has some significant policy ramifications in terms of will governmental entities be willing to entertain settlement agreements if they are exposing themselves to a greater waiver of immunity than they were in the first place? Do you see what I'm saying? If they weren't liable for a tort claim for fraud or fraudulent inducement in the first place, you know, should we expand the waiver of immunity beyond what it was to start with? Do you see what I'm saying?
I do, and I agree with your interpretation of my argument. It is a novel issue. There's no case law on it. I'm relating it to the fact that the Supreme Court, this court has agreed that settlement agreements, which were not originally in the 271 government code for breach of contract, there was no waiver of immunity. The Supreme Court has said there in fact is waiver of immunity now. So they've expanded it. My argument.
Is it an expansion, or is it a carryover from the waiver of immunity that applied to the underlying claim? I mean, Lawson seems to make a lot of sense that that if a governmental entity is not immune to a claim and it chooses to enter into a settlement, there's a logical disconnect if you then say that the governmental entity can't be held responsible for a breach of that very settlement agreement when there's an underlying waiver of immunity. That's a different thing than saying that somehow the courts created a new category of immunity for settlement agreements.
I agree. It's a carryover in regards to the initial immunity that was waived or that had been waived. But in some instance, the Fifth Circuit has even said that if a governmental entity is sued for a claim for which they do not have immunity, and then either counterclaim or remove that claim to federal court, then they waive the immunity. And even though they weren't immune from that initial claim, once they act in a certain way, they waive immunity, and then they would essentially waive immunity for any settlement agreement regarding that claim too. So logically, I agree. Logically, Lawson makes sense. We don't want governmental entities, and this is what the Eighth Court of Appeals held, entering settlement agreements where they don't have to do anything, where they don't have to rehire someone, which is what is being argued here. We don't have to rehire her. We just have to pay money. Logically, I would say then the same governmental entities should not use fraud or inducement in order to obtain those settlement agreements and then later claim immunity on that issue too, which is what appellees are claiming happened here. They were told at the mediation, you will be rehired. Statements like within 6 months, welcome back to the county. And now the county's claiming, no, it was just an eligible for rehire. When we said those things, we didn't mean it.
At a minimum, you would have to allege that. I mean, I don't think your pleadings contain any allegations about the basis for waiver of immunity, right?
Regarding specifically outlining Lawson or Hamilton and the settlement agreement waiver, the pleadings do not state that, Justice. It states fraud claims. Sorry.
And that was kind of my take on the petition. And reading the petition, it doesn't address Lawson or Hamilton, and to a certain extent, it doesn't address the argument that you're now making in regards to the fraud or fraudulent inducement claims, which is a step, I think, away from Lawson. But yes, so I mean, the burden is on the plaintiff to plead the jurisdictional facts to overcome the government's immunity.
And in the event that those specific cases have not been pled, it is at the court's discretion to grant motion for leave to amend that pleading to add jurisdictional facts, if the court agrees that adding those facts could cure the jurisdictional issues here, and we would ask for that. I see my time's almost up. Are there any specific questions or issues you would like me to discuss before concluding my argument?
No.
Okay. And just to restate, the plea to the jurisdiction, the denial should be affirmed. The trial court denied that. The trial court looked at the same issues, and here there is a fact issue as to whether this contract, this clause, this will be rehired clause is ambiguous, who was supposed to perform, whether the appellees performed their duty, and whether the county breached their duty in either inaction, not rehiring or not getting the approval, or if the court finds that it is the responsibility of the appellees to obtain that approval by the deciding official somehow, did the county interfere? Did the county act inconsistent by not treating them as reinstatement officials or reinstatement employees? And if so, Texas law has stated that is tantamount to a breach. Fact issues exist here, jurisdictional. Hamilton and Lawson say we can sue for breach of settlement agreement. Thank you, Justices.
Thank you. Mr. Gomez, rebuttal?
Yes, Justice, thank you. First and foremost, I would like to address the appellee's counsel's argument regarding whether or not there's a fact issue. Time after time, counsel addresses or presents a fact issue as one of contract construction, which is clearly a question of law. He says there's a fact issue because the contract or settlement agreement is ambiguous. Nonetheless, the record shows otherwise. Both appellees conceded under oath that they understood the settlement agreement to require the approval of a department head or elected official before they were rehired. In fact, one of them even specifically said under oath that it would not be a breach if she were not rehired as a result of this lack of approval. So I think there cannot be any meaningful dispute that the language in the settlement agreement is ambiguous. Furthermore, with regard to Mrs. West's statements, I believe they are being attributed improper significance because Ms. West did not negotiate, did not review it, did not know what the parties intended in the settlement agreement. Furthermore, the threshold should not be whether or not Ms. West did or say anything because Ms. West was not the subject of the settlement agreement. The subject of the settlement agreements were department heads or elected officials. If there would have been an issue of fact or something to the effect that appellees wanted to argue that department heads or elected officials depended on Mrs. West's statements, then that should have been pled because that is on the burden of the plaintiff to prove the necessary jurisdictional facts to show that they indeed have a valid cause of action.
Mr. Gomez,
Yes.
could you respond to the information about the motion for summary judgment and why it hasn't been set and heard? If you're saying that the jurisdictional issue is intertwined, couldn't the county simply have sought this, or set this summary judgment motion for hearing and pursue the argument with that procedural vehicle?
When it was presented before the court, and a lot of this is not on the clerk's record, Justice Palafox, but when it was presented before the trial court, we were told we would have a hearing on the plea to jurisdiction, and then the plea to jurisdiction was just denied. So I don't know why the trial court decided to go the way it did. With regards to the summary judgment, it was presented by submission, but it was never ruled upon. So I don't know what the trial court's reasoning was behind that. Nonetheless, the plea to jurisdiction is a question for the law that was denied, and the county's opinion was wrongfully denied, and that's why we are seeking to remedy this before this honorable court. That's the extent of the reasoning that I know behind the trial court's decision.
Do the arguments have any distinction between the argument the county presents in the motion for summary judgment and the argument in the plea to the jurisdiction, or do they manage to mirror themselves in this particular case?
There is some distinction because in the motion for summary judgment, we were not arguing jurisdictional with regards to the breach of settlement agreement claim. In fact, what we did was we filed the special exceptions requiring the appellees to show why they believe that they were entitled to employment or why they believe that the county had a contractual obligation to rehire them. Because again, the county was under the opinion they have not pled sufficient facts to demonstrate why they were entitled to this remedy. Thereafter, the special exceptions, I believe, I don't recall whether the ruling was ever made. I don't believe there was. There was a lot of motions that were made without any rulings. And eventually we asked for leave to amend to amend our plea to jurisdiction because the trial court was alluding to the fact that Rule 54 was inapplicable unless we specifically denied it. It was specifically denied, and then that's when we followed our plea to jurisdiction, Justice Palafox.
Okay, thank you.
Yes.
Mr. Gomez, I wonder if you can address again the Alamo Heights and Miranda precedents in terms of, neither of these were contract cases. And they didn't feature your argument that by denying the effect of a condition precedent, that a contract could be acted upon. It seems to me that these are very different precedents you're relying on, and both of them involve some element of burden shifting where the court is trying to figure out whether a claim fits within some statutory waiver of immunity, whereas this case, could be viewed fairly straightforwardly as a breach of contract in a case where there is an underlying waiver of immunity, and so why should Alamo Heights and Miranda have application to a contract issue here, right? They are different cases.
I agree with that, Justice Massengill. The reasoning behind, or why the reason why we're including those cases more than anything is they address immunity with regards to jurisdictional facts. I understand that the way that they are addressed in the employment context issue. Nonetheless, this burden shifting analysis that occurs during the employment cases is almost identical to that burden shifting that occurs once a party specifically denies a condition precedent. Once a party specifically denies the existence or the satisfaction of an underlying condition precedent, then the burden shifts back on the plaintiff to prove or counter the challenging party's negation or the existence of the condition precedent.
Okay, but in Miranda, it was an allegation of gross negligence that was required, and in Alamo Heights, it required an allegation to overcome the evidence that had been brought forward of a facially non-discriminatory reason for the employment action. And here, this is a contract dispute, and there is an allegation that the conditions precedent were satisfied in the plaintiff's petition. So, either we have to interpret this contract as a jurisdictional threshold, which is what you're inviting us to do, or it's not a jurisdictional question at all. It's a question for the merits, and I'm just having a hard time understanding why we shouldn't view this as the jurisdictional threshold has been crossed with respect to a settlement agreement that involved a claim an underlying claim for which immunity had been waived, and why we ought to view this as a case where we have to resolve the merits of the contract question at a jurisdictional stage.
Yes, Justice Messingo. The immunity in this case is waived similar to that of the case in Miranda or in Alamo. It requires that a certain action or certain cause of action be pled sufficiently to show that the parties have alleged a valid cause of action.
Okay, but if it's a pleading question, hasn't the pleading standard been met?
No, Justice, we're saying it has not been met because we have specifically denied that the satisfaction of a condition precedent has been satisfied.
Right, and they've specifically alleged that it wasn't, and I'm not aware of any pleading standard like a special pleading like for fraud or gross negligence that would require them to plead something more specific.
Under Texas Rule 54 of the Civil Rules of Procedure, once a party denies this specifically, then the party is required to prove essentially the satisfaction of condition precedent. The same applies under the two cases that I cited earlier. To save time, I won't cite them again, but if the court will like me to address them, I will. And so our reasoning goes that without satisfaction of that condition precedent, without being able to plead that they even have a contract, and there is no valid cause of action. This is done almost in a policy question to avoid the county being sued by numerous people. I'm sorry, just may I continue to respond?
Yes, please.
Okay. And this is almost a policy issue because we don't want the county to be sued on meritless claims. We want the county just to be sued on a contract issue or when there is no contract issue, because that requires spending the county's resources to defend meritless trials. And so that is why we believe that an issue regarding immunity of the case presents a question of as to the jurisdictional stance of the claim.
Okay, but Rule 54 says in pleading the performance or occurrence of conditions precedent, it shall be sufficient to aver generally that all conditions precedent have been performed or have occurred. So the text of Rule 54 seems to be satisfied here.
Right, and then the two cases, and I'll cite them again, Justice. That's Gray 228 Southwest 3rd 431, and then citing Texas Supreme Court case 669 Southwest 2nd and 104. Both state that once a party specifically denies a condition precedent, then the burden shifts on the party on the plaintiff to prove that they have satisfied the condition precedent.
But here the issue is the way I understand it is whether there is even a condition precedent. I mean, you're asking, I think the appellee is saying it's ambiguous and that's something that the contract, so that the trial court needs to address. But you're saying this is the interpretation. They haven't shown that they satisfy. First off, there's a condition precedent. They haven't shown it, so therefore their jurisdictional facts fail. But we would first have to agree with your interpretation of the contract. Is that not correct?
That's correct, Justice Rodriguez. And if I may present why we believe what the county believes is a condition precedent?
Yes.
Okay. First and foremost, it's the conditional language that is used. This court has recognized that when conditional language, such as subject to, is included in the contract, and that is a clear indication of the party's intent to create a condition precedent. Second is that by examining the entirety of the whole agreement, we can see that anywhere where the parties intended to create covenant language, they use the words agrees to. For example, it states that the parties agree to settle the case for $45,500. It states that the county agrees to pay the $45,500. And It also says that the parties agree not to rely on any statements or presentations made by anyone to include the attorney. So everywhere where the parties intended to create covenant language, it uses the words agree. In fact, one of the only places that it does not use the words the parties agree is where it conditions the appellee's rehiring on the approval of a department head or an elected official. And lastly, we know that this is a condition precedent because if we were to treat it like a covenant, then it would mean that for example, the appellees would be in breach each and every time the county posted a job opening and they didn't apply for it or they didn't approve it. Or alternatively, it would also mean that if they wanted to be the county public defender or they wanted to be an assistant county judge, they can do so by simply just by applying for it, which is clearly an absurd and unreasonable result to interpret the settlement agreement in that way. And so for those reasons, we believe that it's clearly an indication that it was supposed to be intended to be a condition precedent and not as a covenant, as the appellees argue.
All right, thank you very much, Mr. Gomez. Mr. Baeza, your case will be submitted on the briefs and your excellent argument today. We appreciate your participation virtually and thank you.
Thank you, Justice.